Good afternoon, Your Honors. Donald Caparella of the Nashville Bar. I represent Unrefined Oil Company in this case. I'd like to reserve 3 minutes for rebuttal.
Three minutes?
3 minutes, yes, sir.
That'll be fine.
This case involves a contract for an oil and gas lease between the plaintiff, Mr. Jones, who is the owner of the property, and Unrefined, who is the well operator. Unrefined is primarily represented by a person, Brendan Miller, so I may use Unrefined or Mr. Miller to talk about that. The lease had two key provisions that are important on this appeal. The first is the lease required that the production of oil cannot cease over any 90-day period. So it's got to be pumping oil, it's got to be demonstrated to be pumping oil every 90 days. The second one is that the defendant, Unrefined, must sell a load of oil at least once annually. This case is about the first party breach rule. When a party materially breaches a contract, the non-breaching party is excused from any further performance. Here we have accusations that both sides breached this lease, and when that happens, the court must determine who breached first. If the first party if Jones is the first party to breach, then any non-performance by Mr. Miller or by Unrefined is excused.
Excuse me for interrupting,
Yes.
Counsel. Was that specifically pled in the complaint?
It was not pled in the terms of first party to breach, but it was pled in an answer and counterclaim in that several actions that amounted to a breach were pled in the answer and countercomplaint. Specifically, that there was harassment and interference, that the electricity was cut off improperly. There were numerous actions, bad actions by Mr. Jones that amounted to a breach, but the exact magic words of breach of contract were not used. However, and you don't have to, the rules of civil procedure says you don't have to say a first party to breach is an affirmative defense as long as it's in the countercomplaint. So I think the allegations of the countercomplaint can be fairly read as a first party to breach.
Was it an affirmative defense in this case?
It wasn't pled that way, but it was pled in the countercomplaint. It was several actions by Mr. Jones were listed that were considered breaches that would cause the lease to be breached.
So are you suggesting that it was tried by implied consent?
It was. That's the third argument I have, and here's how we know it was tried by consent. After all, the trial court found that the reason why the lease terminated was because a sale of oil did not happen in that annual period of time. Well, our position is that Mr. Jones terminated the lease a month early, in the 11th month, by filing a notice of termination. And that notice of termination that was filed in the Record of Deeds office was an exhibit at trial, and Mr. Jones was specifically cross-examined about that. And he specifically admitted that, yes, he had filed that in the 11th month of a 12-month lease. So therefore, it was tried by consent because they argued that that's a breach. You breached first.
As I understand, the trial court did not specifically address who committed the first material breach in its findings. Is that correct?
That's exactly right, and that's why we say that because the court made a finding of fact as to one of the claims of breach by the plaintiff and said he was wrong about that. It made no finding about our breach, about our claims that he breached first, and so therefore you can do a de novo review. When a court fails to make any findings of fact, as long as the issue is before you, and we submit it was tried by consent because this entire case is focused on the notice of termination of lease, which is undisputed was filed in the 11th month of this annual period. And Mr. Jones was cross-examined extensively about that lease, and he admitted that he filed it a month before the year had passed.
Well, if the trial court did not make any findings, is your client suggesting that this case needs to go back for findings of fact by the trial court with regard to a first material breach?
No, the law is very clear in the Gooding case that when there's an issue about a finding of fact and whether a contract was breached or not can be a finding of fact, you can do a de novo review of the record. And the reason why that's easy in this case, it's undisputed. In the record is Exhibit 5, which is the notice of termination of lease. I brought a copy with me to hand to you if you want it. In that notice of termination of lease, which is Exhibit 5, that was filed in the Records of Deeds Office, it expressly says this lease is terminated because you didn't pump oil every 90 days. So that's the first material breach. So you don't have to do much de novo review to determine that that's the first material breach. Now, it turned out that he was wrong about that allegation. The trial court said, no, he did pump oil every 90 days. So that provision of the lease, you lose on, Mr. Jones. And he simply didn't get to the second thing, even though the court was faced with a cross-examination about this very notice. So there's no dispute about that. There's also a second material breach by Mr. Jones. On December 23rd, which is in the 11th month, which is right after the notice of termination was filed. Oh, and I want to make a point about the notice of termination. It is a material breach of a contract to unilaterally terminate the contract and not give notice of that. He filed it in the Records of Deeds Office, but he didn't ever send it to Mr. Miller. And in the McLean case, if you manifest an intent not to be bound by a contract, which he did in writing, says it was terminated, and you don't give notice, you have breached the duty of good faith and fair dealing in every contract because you've now terminated a contract, but you didn't tell him. So that's actually a third material breach. But another breach is on December 23rd, Mr. Miller did a health check of the well and had pictures showing that the electricity had been rerouted from the well to pump the well, because it was an automatic pump, and it pumped twice a day based on the electricity. But the electricity was rerouted on December 23rd. He has pictures of it. He also has all these cables strewn about, and essentially he has pictures and his own testimony that the well had been tampered with. At that point, the well was basically inoperable, and he still had 2 weeks from then to sell oil. So that's another material breach. Now, there's no issue here that there was no sale of oil in that year.
Did the trial court make any findings with regard to each of these asserted first material breaches? You've articulated several. Did the trial court make any findings or determinations with regard to each of these breaches?
No. All he said was that you didn't sell the oil within the year, therefore the lease terminated on its own terms. The court simply didn't address our allegations that he had done the various things that we pled that he had done wrong, and including the issue that was tried, which is whether this notice of termination. So when the trial court doesn't make those findings, you are supposed to do a de novo review to determine where the facts are on that. And since we have of record a notice of termination of lease for a reason that was not true, which is that the well didn't pump every 90 days, the trial court expressly found that one of the arguments that the lease terminated, which is that he didn't pump oil every 90 days, that's not correct. He did pump oil every 90 days. But then the court simply ignored our allegations of all the things that Mr. Jones did wrong. And since one of them is undisputed, he filed a notice of termination of lease on the 11th month for a 12-month obligation. You can find that he was the first party to materially breach without even addressing the electricity and tampering with issue. So, yes.
Did the trial court make any findings as to whether or not anything that Mr. Jones did here prevented your client from selling the oil that had been pumped and was stored in the tank?
No, he didn't specifically make any findings about that. Now, we have evidence that...
And that was the basis for finding that your client had breached it, was it didn't sell the oil, correct?
He didn't sell the oil and didn't make the payment that went along with it, yes.
Yeah.
That was the sole reason why he said the lease terminated. And it's our position that he had after the notice of termination was executed on December 3rd and then recorded on December 18th, he still had time to sell oil, and therefore it was terminated prematurely before he had a chance to actually fulfill his obligation of the contract. Now, and this is important because the first party to breach rule says that if you manifest an intent not to be bound by a contract and you do it wrongly, you're the first party to breach. And that's what he did with the notice of termination. We don't actually have to show that he prevented any sale during that period of time, because if he had given notice of that record filing, that would have given Mr. Miller a chance to cure this supposed breach. He would have had time to sell oil at whatever price the market would bear at that time. And he never did that. So if you, under McLean, if you unilaterally terminate a lease and don't tell the other side, and we have proof of it because he filed it in the Register of Deeds office, you're the first party to manifest that you're not going to be bound. And what's importantly is in that notice of termination, he said, the reason I'm breaching the lease is that you didn't pump oil every 90 days, and the trial court expressly found that's not correct. So he had no basis to terminate that lease in the 11th month. And therefore, the reason why the court found that the lease terminated, because you didn't sell oil within 12 months, doesn't matter anymore, because he's excused from that non-performance because the other side was the first party to breach. Now, the other side has appealed the court's ruling on whether the oil was pumped every 90 days. They've done a cross appeal. And they are arguing that they get the same de novo standard review that we want because the court didn't make a proper finding of fact. And I submit that the court did make a proper finding of fact, because the trial court said, I find that the well was pumped every 90 days during that period of time. They quote from an oral ruling, but the judgment, he says it was pumped. That is a factual finding that it was pumped. And there's numerous statements, numerous citations in my brief showing all the testimony Mr. Miller made, saying that he observed the well was pumped, the least of which is that the number of barrels kept growing every 3 months. So we know it was pumping the whole time because it was an automatic pumper. So we submit that they can't overcome the presumption of correctness for their issue that they raised on appeal. So thank you, Your Honor.
Every time for rebuttal. We'll hear from the appellee.
Good afternoon. Doug Fields of the Cumberland County Bar. It's a pleasure to be back here again. Hope that doesn't change before the day's over.
We certainly want to issue our opinion before the day's over, so.
Awesome. I worry about it later. I guess just from my own feeling, I didn't feel well the day of this trial. When I went back and looked at everything, I was kind of disappointed in some things. I'm not Clarence Darrow, but sometimes I do a little better job. Also read my brief last night before I came over here, and I thought, my goodness, how wordy. I probably could have wrote that about half as much. I've said an awful lot already. It's my experience. You read those things. I'm not inclined to recite it all over to you again. It is obviously our position that the first to breach issue and breach contract was waived. And I think it's important that they got up at trial and announced this is not a breach contract. We're not here about a breach contract. And I don't know if I can actually get up at trial and announce to the court and counsel before we get started, I'm not here about breach contract. And then on the side, I'm really trying to breach contract, and when it's all done, never say anything to the trial court, and I've preserved that issue for appeal. I'm going to have some interesting positions I'm going to take in my trials in the future. Respectfully, not only is it unclear that they're there on first breach and breach of contract, but they announced that's not what they were there to argue about. And I just don't see how you get around that when you come back to this court and say, well, that's exactly what we were trying. I think the facts in this case are not consistent with the Foreigner versus Southwest Manufacturing that they rely upon. I think it's much more consistent with Alexander versus Armentrout, which is 24 Southwest 3rd 267, 2000 case by Supreme Court, where they said this is never mentioned in the trial court, never raised along the way, and it's waived when you get it up on appeal.
Counsel, excuse me for
Sure.
interrupting. Was this issue of first material breach tried by implied consent?
Not in my mind, Your Honor. It just wasn't. I mean, I never perceived this. My understanding of what we were trying there is just whether or not the lease had terminated by its own terms, whether or not anything had happened that allowed the lease to expire. And their position was, it hasn't expired. We haven't done anything to let it expire. And he's done some things that we feel are interference, and we want you to restrain him from doing that and make him pay the cost to rewire the well. That's how I interpret this. And when you get up in court and say, I'm not here about a breach of contract, then that's what I think we're there about. I don't think our complaint alleges a breach of contract at all. It's a declaratory judgment asking whether or not the lease is expired. We didn't make any allegations that they breached anything. And as I say in my brief, I don't think you have a breach of contract if they don't pump the well. That's not a breach. They don't have to pump. If it's not producing enough, they could just sit back and let the lease expire. It doesn't matter. There's nothing we can do about it except lease it to somebody else. We've just asked, Your Honor, have they let the lease expire or have they not? We thought they did because it appeared to my client that it had been inactive. Now, if in fact they were trying that by some kind of implied argument that I didn't realize, I'd submit that we actually proved that the appellant was the first to breach. And if you look at paragraph 4 of the lease agreement, it grants the lessor the right to have gas from that well free of charge and requires him to make his own connections to get that gas. And at trial transcript, page 41, my client's testimony was, and it's uncontroverted, that he could not get gas. That was the whole problem. He wasn't getting gas and couldn't heat the house, couldn't heat the trailer there. And the well had backed up with oil. It needed to be pumped to let the gas out. That he wired it up so that he could get some gas out of it, made his own connections, got it going, pumped it out, got heat to the house. Well, it was their obligation to pump it and let us have gas. That was the very first thing that happened and brought everything on. The notice of termination was filed after that. The pump is wired up after that because he can't get gas. So everything that flowed thereafter by their own argument was a result of them not doing what they needed to do to allow gas to get to the mobile home and warm it. And that's what got the problem started. I'm at a loss of how Mr. Jones prevented the company from selling oil when the company, by its own testimony, had to be operator of the well, and it didn't become an operator until after the year expired. All through the entire time, their testimony is you have to be a well operator, do a division order, and get the oil picked up. They didn't become one until after the year expired. How do we prevent them from doing something they can't do in the first place? I don't understand how we could do that. So I think the trial court got it right. Now, and I'll finish early, and you'll have lots of times for questions. Somebody may have one. On the counter appeal, you know, it's kind of vague in there. I think we have the better proof, respectfully. The only thing, you know, it can be accounted for that the tank had more oil in it at the 2 times or 3 times it was checked. The only thing that says that well was pumped between April and December is the fact that they changed their admission at trial and tried to say, I saw it pump, after they said they hadn't seen it operating. I think the proof really doesn't support that, and that the prior owner had cut off the electricity because nobody was paying them for it, and my client didn't have anything to do with that. And I agree, he is awful on dates, he doesn't read and write. He couldn't even recite the months in the correct order at trial, if he couldn't. But I think he does know when it gets cold and when he needs heat, and I think we all know that it doesn't get cold in August or September. At best, it's going to happen in October. So I think the proof really supports that the well wasn't pumped, and the trial court took his testimony over his admission, and I don't think that was properly done. I will say, counsel said the well was inoperable December 23rd. I don't think there's any proof in there it was inoperable. It was hooked to an alternative electric source, And why in the world would a man hook it to an alternative electric source if the electric had been working all the time? Well, it's the only reason he would go out and rewire that, because it didn't have electric to it. He needed to get it pumped. So I think it was operating on December 23rd. It just had a different electric source. And, you know, about the manifest intention not to be bound by the lease agreement. My client did file a notice of that the lease had terminated. If you read that termination, it's in the record. He says in there that he believes they haven't pumped it and it's expired by its own terms. But at the same time, while he filed that, when they come back on December 3rd, my client didn't stop them from coming to the well, doing their inspections, doing their measurements, come pick up oil and sell if they want to. He didn't interfere at all. When they came back in January, he didn't interfere. So I don't think the record really shows he had an intent not to cooperate and not to do it. He just set forth his notice that I don't think this thing's operated for well more than 90 days. And if the lease is terminated, I'm all on board with that. I'll be the operator. That's all I would add to what I had to put in there. And I'll answer any questions that you might have. If I'm capable, I'll give it my best shot.
I hear none, so thank you.
Thank you very much.
We'll hear from the appellate in rebuttal.
Your Honor, they didn't raise the waiver issue till their brief, so all of my argument is in my combined reply brief. And on page 8 of my reply brief, I list 4 allegations in our answer and counter complaint that raise things that Jackie Jones did that were essentially breaches. Jackie Jones has interfered with the oil and gas lease by harassing the operator and his employees who maintain and work on the well. That's one. Mr. Jones or his agent has tampered with and caused damage to the well's electricity, thus causing issue with the production of the well. Number 3, Ronnie Stevens is employed by Unrefined Oil and has been denied by Jackie Jones entry onto the property where the well is located to check the well. Number 4, due to Mr. Jones's claiming to be the operator of the well, Baird Oil Company will not pick up the oil that has been pumped into the tank until they have proof who the court operator is. That put the other side on notice that we were alleging that Mr. Jones had done some things that amounted effectively to breaches of this lease as well. And then at the trial, and this is on page 11 to 12 of my reply brief, I quote extensively from the cross-examination of Mr. Jones, where he's asked about this notice of termination.
Excuse me for interrupting.
Yes.
Counsel, was it represented at any time during the trial that this was not a case about breach of contract?
I don't deny the quote that he said, that the lawyer said, we're not here about a breach of contract, but that statement cannot overturn what the allegations in the complaint were, and especially can't overturn the fact that the notice of termination was admitted into evidence and he was cross-examined about it, and that was the argument that he indeed breached this lease prematurely and prevented my client from being able to legally sell the oil. So it was tried by consent at that point. That 5 words does not amount to a waiver. It may have confused people, but it doesn't overcome the written pleadings and the fact that it was tried by consent because the notice of termination is in here. So,
At what point during the trial was that articulated? At the very outset, or at the end of the trial?
I don't specifically remember. There's a citation to the record. I believe it was before they got the trial started, something like that. But again, the notice of termination is important because it says the lessee having failed to perform the lease has terminated pursuant to its own terms. So remember, you don't have to prevent somebody from performing to be the first party to the breach. You don't have to bar the door to the well. You just have to manifest an intention that you're not going to be bound by the lease, which they did by recording this notice of termination. That terminates it and excuses the non-performance in this case. And I think if you carefully review my brief, which goes into great detail, more than I can in oral argument right now, and lays out why it was not waived because of all the different ways we preserve the issue, I think you will find that waiver is not the issue on appeal. The issue is whether or not they were the first party to breach. Thank you, Your Honor.
Our thanks to council for both sides. Y'all have a safe drive back to the plateau and then over the plateau. If you would, please recess court till 9:30 tomorrow morning.
Yes, sir. Thank you. Happy Valentine's Day, everybody.
Yeah.
Scheduled our snow day back on Valentine's Day.